Okay, so I want you to picture something. It's November 2nd, 1990. You're in Pazik City in the middle of this massive construction boom.
Everywhere you look, buildings are going up, skeletons of steel reaching for the sky.
Exactly, and you're looking up at one in particular, the Renaissance Tower. Sounds pretty grand, doesn't it?
It does. It sounds like progress. But around 1:30 that afternoon, that picture of progress becomes, well, a scene of absolute horror.
Yeah, because we're not here to talk about architecture today. We're here to talk about the moment a man named Jose Huego, a construction worker, fell 14 floors to his death.
And this wasn't just a simple slip and fall. This was a catastrophic failure of equipment.
Right. And it kicks off this incredible legal battle between his widow, Maria Huego, and the construction giant Consunji Inc., a real David and Goliath story.
It really is. And the company's defense is fascinating. They basically argued, one, we're not liable, and two, even if we were, the widow already took a small payout, so she can't sue us. She'd already made her choice.
And that's what we're going to get into in this deep dive. We're unpacking the Supreme Court decision, Consunji versus Court of Appeals, to really understand three legal ideas that can make or break a case like this.
First up is the hearsay rule, what's actually allowed as evidence. Then there's this amazing Latin phrase, res ipsa loquitur.
The thing speaks for itself.
Exactly. And finally, the one that almost ended this whole case before it began, the doctrine of election of remedies.
This idea that you have to pick a door, and once you walk through it, you can't go back. It's a legal trap, really.
It can be, but this case shows how the law can also protect people who don't know their rights.
So let's start where it all began, 14 floors up. What exactly happened to Jose Huego?
Okay, so Jose's a carpenter. He and two other guys are on a platform in the elevator core of the tower.
And this isn't like a modern enclosed lift. The documents make it sound a bit makeshift.
It was a heavy piece of equipment, a channel beam with plywood laid on top for flooring. The whole thing, maybe 15 feet long, was hanging from a chain block, a crane, essentially.
So they're just suspended there.
They are. And then suddenly the connection fails. The single bolt or pin holding this massive platform to the chain block just loosens. It gives way.
And the whole thing just drops.
The entire platform just plummets, 14 stories all the way down to the basement. Jose was killed on impact.
Oh, that's horrific.
Well,
what about the other two guys?
Incredibly, they survived. They managed to jump or grab onto the building structure as the platform fell away from under them.
Wow. Just unbelievable luck for them. So the police are called in. An investigation starts.
Right. And this is where we meet PO3 Rogelio Villanueva. He's the investigator on the scene.
But he gets there after it's all over, right?
Yeah.
He didn't see the fall.
Correct. He didn't see the accident happen. He investigates, he talks to people, and he writes up a report. And in that report, he concludes the cause was the bolt breaking or being removed.
And this report becomes a key piece of evidence for the widow Maria.
It's her proof. But when she tries to use it in court, the company's lawyers jump all over it.
Objection, hearsay.
That's the one. And, on the surface, it's not a bad argument. The hearsay rule says you can only testify to what you personally saw or heard.
So Villanueva didn't see the bolt fail, so he can't testify that the bolt failed.
He can only testify that, other people told him it failed. And Consunji argued that makes his report inadmissible. It's secondhand information.
A classic way to try and get evidence thrown out.
Yeah.
But the court didn't go for it. Why not?
This is such a smart distinction by the court. They pointed out that Officer Villanueva actually took the witness stand.
So he could be cross-examined. They could question him directly.
Exactly. And the court said, look, he's not testifying about the fall itself. He can't. What he is testifying about is what he personally observed at the scene, his own investigation.
The crime scene, basically.
Right. He testified that he went to the site, he saw the crushed platform with his own eyes, and this is the key part, he had the workers bring the chain block to the station.
He impounded the evidence.
He physically held it, and he testified to what he saw. He saw the chain was detached, and he saw that the connecting pin, the bolt, was gone.
And that's not hearsay. That's a direct observation.
It is personal knowledge. He perceived the absence of the bolt. So the court ruled his testimony was valid proof that the bolt was, in fact, missing.
Okay, so step one is complete. They've established the bolt is gone. But the company pivots, right? They say, okay, fine, it's missing. Prove we were negligent.
Yeah, prove it was our fault. Maybe the bolt just broke. Maybe it had a defect. It's a good question, because how can the widow possibly prove what happened in that specific moment?
She can't. The only person who really knew is gone.
And this is where the law has this incredible tool for situations just like this one. It's called res ipsa loquitur.
The thing speaks for itself.
You got it. It's a rule of evidence that basically says some accidents are so unusual that the accident itself becomes the proof of negligence.
It flips the whole script.
It does. It shifts the burden of proof. Now, instead of the widow having to prove the company was negligent, the company has to prove they were not negligent.
But you can't just use it any time, right? There's a test.
A three-part test. First, the accident has to be the kind of thing that doesn't normally happen without negligence.
I think a platform falling 14 floors qualifies. That's not a freak act of nature.
Not at all. Second, the thing that caused the injury, the platform, the crane, had to be under the defendant's exclusive control.
That's DM Consunji. Their site, their equipment, check.
And third, the victim can't have contributed to the accident themselves.
Right, Jose didn't do anything to cause the fall. He was just doing his job.
So all three conditions are met. Res ipsa loquitur applies. The court now presumes the company was negligent.
So the ball is in their court. They have to prove they were careful. How do they try to do that?
Well, this is where it gets a little ironic. They try to submit a sworn statement, an affidavit, from a foreman named Ferdinand Fabro.
And what did Fabro say in this statement?
He claimed they had safety meetings, that they inspected the equipment, that they did everything by the book. Basically, we exercised due care.
Okay, so on paper, that's their rebuttal.
But here's the kicker. Remember how they made such a big deal about the police officer's report being hearsay?
Yeah, it was their main defense.
Well, they submit Fabro's written statement, but they never put Fabro on the witness stand to be cross-examined.
Wait, seriously? They tried to use a piece of paper as a witness.
That's exactly what they did.
But that's textbook hearsay, the very thing they were complaining about.
It is. The court called them on it immediately. They ruled Fabro's affidavit was inadmissible hearsay. And just like that, the company's only evidence to prove they were careful was thrown out. The presumption of negligence stood.
That is just a massive own goal.
Yeah.
But okay, they lost on the facts.
Yeah.
But they have one last card to play, and it's their ace, really.
The election of remedies.
Right. This has to do with the money Maria, the widow, had already received.
Correct. The company points out that a few weeks after the accident, Maria Wago filed for and started receiving death benefits from the state insurance fund, a monthly pension.
Which is standard, right?
Right.
For a workplace death.
It is. But under the labor code, there's a rule. You get a choice. You can either take the smaller, guaranteed payout from the state insurance,
Correct.
or you can sue the employer in civil court for much larger damages based on negligence. But, and this is the important part, you generally can't do both.
It's a fork in the road. You pick one path.
You pick one. And DM Consunji's argument was powerful. They said she already picked her path. She took the state money. She waived her right to sue us. Case closed.
And under the normal rules, that would be correct.
It often is. That argument wins a lot of cases.
So how did she get around that? Because obviously she did.
This is where the Supreme Court gets really deep into the idea of what a choice actually is. They looked at a precedent called the Floresta case, which created an exception.
An exception for what?
For ignorance. A waiver is only valid if you knowingly give up a right. You have to know what you're giving up.
You can't give away something if you don't even know you have it.
Precisely. And this is where the timeline becomes everything. Let's look at the dates.
Okay.
Maria filed for the state benefits on November 15th, 1990.
About 2 weeks after her husband's death.
Now, when was Officer Villanueva's police report finished? The one that confirmed the missing bolt and the company's negligence.
You said earlier. It was November 25th.
10 days after she signed the papers for the pension.
Wow. So when she made that choice, she had no idea there was clear evidence of negligence.
She knew her husband fell. She did not know why. She didn't know about the missing bolt. She didn't know the company had failed to maintain its equipment. She was operating in the dark.
And the court considered that.
They considered that, and they considered her personal circumstances. She testified she only had an elementary school education. She said she had no idea there was a difference between the two types of claims. She was just a grieving widow trying to survive.
She just needed money to feed her family.
The Supreme Court said her election was not a valid, intelligent choice because she was ignorant of the most crucial fact, the company's negligence. You can't be said to have chosen between two remedies if you don't know the second one even exists.
That's a profound ruling. It protects people from being locked into a bad choice they made before they had all the facts.
It really is. It says you can't use someone's lack of information against them, especially when you're the one who has all the information.
So, the bottom line is, she gets to sue.
Mm-hmm.
And she wins. But what about the money? Does she get to keep the pension and the big settlement from the lawsuit?
No, the court still honors the principle of no double recovery. They want to be fair to everyone. So the court affirmed the trial court's award for civil damages, which was substantial, covering lost earnings, moral damages, and so on.
Far more than the pension would have ever paid out.
Oh, absolutely. But they ordered that any amount she had already received from the state insurance fund must be calculated and deducted from the final civil award.
So she's made whole, but she doesn't get a windfall. She gets the bigger award, but has to, in effect, pay back the smaller one.
That's the perfect way to put it. Justice is served, the negligence is paid for, but the system remains balanced.
This case really is a journey. From a missing bolt, to the definition of hearsay, to a doctrine that presumes guilt, and finally to a ruling that protects a widow's uninformed choice.
It all came together. The evidence was allowed in, the negligence was presumed, and her waiver was invalidated because it wasn't a true choice.
You know, what's really striking is that DM Consunji must have known about the missing bolt almost immediately.
They would have been the first to know.
So they likely knew about their own negligence when they watched her file for that small state pension on November 15th.
The timeline suggests they did. And they knew if the standard rule held, her signature on that form could save them millions.
Which is what makes this exception so critical. It really puts a check on the powerful. It says you can't benefit from a grieving person's lack of information.
It does. It reinforces that a true waiver, a true choice, requires transparency and knowledge. You can't give up a right you don't know you have.
A fascinating deep dive into a case that is about so much more than just a tragic accident.
It's a masterclass in how different parts of the law can interact to produce a just result.
Well, that is all the time we have for today. Thank you so much for listening.
A pleasure as always.
We will see you on the next one. Stay curious.